Friends, in previous session, we had seen what are the provisions of Armed Forces Special Powers Act and what are the checks and balances and what did the Naga people's case, the decision of the Supreme Court, indicate in that regard. There has been a demand for some time that the provisions of Armed Forces Special Power Act need to be more humanized. Well, this is a security statute to be used in unusual, extraordinary situations which are dangerous. Let us see how can AFSPA be made to look more humane. The action to humanize it would require certain subordinate legislative measures and also steps by the executive. Firstly, Army and the security forces must have clear-cut standard operating procedures, SOPs, and particularly the rules of engagement as to the contingencies in which fire can be opened, what type of fire or force can be used, and this has been indicated by the Supreme Court in Extrajudicial Execution Victims Families Association decision of 2016 that needs to be taken into account. Regarding the statutory measures, firstly, the Army Act provisions, particularly Section 310, which define an enemy, they need to be amended so as to include terrorists and militants. Other options and suitable alternatives have been there, but these two need to be included. And secondly, in the Armed Forces Special Powers Act text, there should be a distinct section, a clause to provide for framing of rules. It is not there presently. Therefore, need exists to frame rules where AFSPA presently has no provision relating to framing of rule. It doesn't give rule making power, and therefore the act needs to be amended by the parliament to provide and insert rule making powers. The rules need to be framed, for example, to define armed forces, which all security forces would be covered within the ambit of Armed Forces Special Power Act. It should clearly indicate the difference between a disturbed area or a dangerous one and bring out the contingencies or examples, which could be an inclusionary definition as to what is disturbed and what is a dangerous situation, and also the threshold levels to decide above to illustrate the number of casualties or say the presence of foreign apprehendees or dead bodies or the type of weapons. So the threshold levels need to be inserted. There should also be a clear provision about the issue of warning before opening fire. The warning would be issued in what language, for what duration, how would it be issued, the mode, and also what caution would be given. Say, for example, don't come out of your house, don't move, don't switch on light, or this would be in operation from this time to that time, etc. Also, where the request for prosecution is withheld or issued, so in that case, the authority, the designated authority should indicate the reasons for doing so. This also needs to be provided under the rules. There is a need to emphasize the distinction between the right of self-defense or private defense and use of excessive force or retaliation. Now, this is what Supreme Court has brought it out in its decision of 2016, that the two situations are totally different, and this needs to be emphasized during trading, in operation, and also in documents. And also it needs to be impressed and brought home that retaliatory and excessive use of force cannot be accepted, even while dealing with a victim who was or who had been a dreaded criminal, militant, terrorist, or insurgent. So, in other words, inhuman force or behavior would not be accepted. With regard to actual operations or missions against the terrorists and insurgents, it is advisable that all such missions should be videotaped, and that would, to a great extent, usher in transparency and accountability. It would be there for all to see. Also, there could be a move to consider instituting incentives and awards for capturing militants alive. And this may cut down the number of those killed, and surely this would be more advantageous with regard to gaining information from them. And thirdly, as far as possible, a civil magistrate should accompany each contingent of army which is deployed for counter-terror or counter-insurgency operations. Where it is not feasible, reasons should be recorded, and this would also be helpful as regards transparency and keeping an independent check. All situation reports which are to be issued on occurrence or at regular laid down intervals, or in the FIRs lodged, they must contain adequate details with regard to, firstly, what was the background information or intelligence that was available before the mission was undertaken, if there was a need for speed and maintaining confidentiality in that mission, what evasive action or opposition was encountered from the opposite side, what force or operation was used, whether it is with regard to the weapons or any other tactics deployed with regard to the militants or insurgents, what was the result or outcome of that operation as regards fatalities, injuries, or damage to property, and together with the details about the persons who have been taken into custody or those who have apprehended or perhaps surrendered, together with a full list of arms, ammunition, or other lethal stores that have been recovered. There is also a need to consider that obtaining a NOC, no objection certificate, should be made mandatory, of course, where feasible, and this could be taken in the case of a rural setting from village and elders, or in urban areas, or even in villages from the owners of property that may have to be occupied, that may have to be sort of used on the spot, or family members as applicable, and in the presence it should be signed as independent witnesses by some persons, like a panchnama is done, and this would also be useful. This should be made a mandatory practice. Rules of engagement need to be drafted and promulgated with greater clarity, in that they must specify and enumerate conditions and contingencies under which lethal force can be used, and they must be strictly adhered to. Another point with regard to 2016 judgment is that merely carrying of weapons in a disturbed area, in prohibition of prohibitory orders or membership of a banned organization, there is a need to clarify and issue orders that this would not be sufficient to brand a person, to treat a person as a militant terrorist or insurgent. What are the other accompanying circumstances, conditions, or evidence must be brought on record. With regard to investigations and probes, it must be obligatory to convene inquiry in all cases of civil deaths where or grievous injuries that have been caused, in cases of allegations of sexual harassment, and the provisions of regulations for the Army Defence Services Regulations para 521 and 522 may need to be suitably amended, and this should be ordered within 72 hours of the incident. In the investigation, a civil official can be co-opted in attendance. Women officers must be taken as members or in attendance, depending upon the situation. The venue of the inquiry should be easily accessible to local public, and proceedings should be conducted in open, and they should be translated, and the local language may be used if required, so that it is an open inquiry and it is not a closed probe which may not inspire confidence. A practice to register FIRs also needs to be encouraged, and this is particularly applicable where there are allegations of extrajudicial killings and fake encounter. Wherever there is a doubt that allegations are about to sort of start, or they have already started, registration of FIR must be registered, and the civil authorities should know that they can advise the local civilian population to take recourse to this. To institute transparency and accountability, uh, perhaps due publicity of cases where disciplinary actions have been taken or are even in progress against military personnel found guilty, blameworthy for human rights violation must be done to achieve accountability and to instill faith and confidence. And also, clear-cut policy guidelines need to be drafted and issued about the issue of denial of sanction for prosecution within the terms of Section 6 of the Armed Forces Special Power. It is to be taken note of that the Supreme Court in its 2016 judgment has said that there are three options available to the state government where it wants to institute convene an investigation. It may be done by way of a judicial inquiry or a probe by the National Human Rights Commission, the State Human Rights Commission, or under the Commissions of Inquiry Act. And therefore, it is noteworthy that the Supreme Court did not repose trust in a magisterial inquiry. Therefore, a need for thorough investigation emerges where there are allegations of either inaction, atrocities, or there have been instances of custodial violence or death, false encounters, illegal detentions, and forced disappearances. These allegations must be investigated. The local NGOs, if they are existing, they may be allowed to lodge complaints. All complaints against army personnel pending in police stations should be probed in a time-bound manner. So there is a need to check, to correct, take corrective action. Evidence of eyewitnesses must be recorded. This too emanates from the Supreme Court decision, and NHRC may be allowed to refer and seek reports this provision, Section 19 of the Protection of Human Rights Act, this also needs to be activated, perhaps with greater force. Outcome of probe. Once the probe is complete, it must be indicated to the next of kin of those persons who have been killed or are still missing, and perhaps Army may now start and by devising a practice and formulating proper procedures for payment of compensation in the cases where there have been victims of atrocities, custodial violence, and fake encounters in the inquiry that have been set up by the military. In the end, it is to be appreciated that the need of the hour is to hold urgent discussion at various levels and consider what are the steps necessary to make provisions of Armed Forces Special Power Act appear more effective, to institute greater transparency and accountability in combating insurgency and terror. Thank you.